This is TWiT.
An appeals court today ruled that the NSA's bulk collection of telephone metadata is illegal. The three-judge Second Circuit Court of Appeals asserted that harvesting the metadata of American citizens, quote, exceeds the scope of what Congress has authorized, unquote. Mark Joseph Stern wrote about the court's ruling for Slate and joins us now. Welcome to you, Mark.
Thank you for having me on.
Thanks for being on. Now, did the court rule that mass metadata surveillance is a direct violation of the Fourth Amendment to the Constitution?
No, the court decidedly did not rule that. Instead, the court simply decided that by collecting so much data indiscriminately with no reasonable suspicion that the people who are creating the data, who are making the calls, might be related to terrorists, the NSA was just exceeding what Congress said it could do. Congress said you can collect tangible objects so long as they are somehow related to some kind of suspicion that there's terrorist activity. And the NSA took that simple mandate and said, we're going to take all the telephony metadata that exists. That's not what it was authorized to do. And so the court said, you're breaking the law. And then the court said, because we can resolve this on this pretty simple, basic statutory ground, we don't need to reach the Fourth Amendment question.
Yeah, just to clarify there, Mark, let's talk a little bit about the Fourth Amendment question and also the players here. So as I understand it, correct me if I'm wrong, this case was driven by the American Civil Liberties Union. And were they basically trying to clear a ruling that the NSA's actions violated the Fourth Amendment? And ultimately here, did the American Civil Liberties Union win?
Yes. So to your first question, the ACLU is very much trying to get a court ruling from an appeals court and ultimately from the Supreme Court that holds that if the NSA collects a ton of data from people with no suspicion that certain individuals are actually terrorists, that violates the Fourth Amendment and that it constitutes an unreasonable search or an unreasonable seizure of people's personal effects. You know, when I make a call to an abortion clinic or a suicide hotline, the NSA winds up getting the information that I, Mark Joseph Stern, made that call. Not that I have made such calls, but you get the idea. That is very personal information, and the NSA is snooping on it. Then the ACLU would like for a court to say that in itself is a violation of the Fourth Amendment. However, the ACLU is certainly happy with today's ruling because what it did was say, look, Congress, you're on notice. We don't like this kind of program. If we did reach a constitutional decision, we would probably say it's unconstitutional, but we don't need to reach that decision. And we're giving you enough time to repeal or let expire this statute. So the problem with the ruling is this: because the court did not rule that did not squarely rule that the program is unconstitutional, Congress could theoretically come back and just rewrite the program, rewrite the mandate, say everything the NSA is doing right now is perfectly acceptable and it's what we authorize. And then you would have no statutory problem. And every court that addressed this issue would have to go right to the constitutional question.
Personally, I think that it absolutely should be ruled unconstitutional. I think that people who think that it shouldn't don't understand the power of metadata. In my own view, I think the metadata is actually more telling than the data. For example, if you know what somebody said, but don't know who they said it to or when they said it or where they were when they said it and all that rest of the metadata, then that's less useful than the fact that this person is in contact with that person 12 times a week. And then, you know, that kind of information is very, very damning for anybody who is trying to have their privacy respected and so on. But shifting gears a little bit, they actually credited Edward Snowden for this ruling. They said, you know, essentially that this ruling would not have taken place without the leaks by Edward Snowden. Were you surprised by this, essentially them giving props to Edward Snowden?
I wasn't surprised at all because it's the only way the ACLU could get this case to court. Before the Snowden leaks, the ACLU had tried several times in several different courts to represent cell phone customers who wanted to sue the NSA and say, look, we aren't quite sure what you're doing, but we're pretty sure it's unconstitutional and that you're snooping on us without any reasonable suspicion. And almost every single court said, look, you're just a Verizon customer. You don't have any proof that the NSA is actually snooping on your metadata. It was pure speculation back then, which is in 2007. Fast forward to 2013, 2014, and today, we have the NSA documents that state specifically every single Verizon customer was surveilled by the NSA between a certain period. And because we have that information, because the ACLU has that information, they can march into federal court and show them the Snowden documents and say, my clients were snooped on by the NSA, and they now have standing to challenge that surveillance. It moved the challenge from speculative to very much concrete.
So, Mark, with everything that you're saying here and with the ruling, why didn't the court issue an injunction that orders the NSA to stop bulk collection of all this metadata?
So it's a great question, and you can tell that the court really, really wanted to. But there's a fundamental idea of judicial restraint when you're talking about a statute passed by Congress. And you want to do everything you can to not strike it down and not hold it up. And so what the court said is, look, this law that we're talking about, which is Section 215, this bulk collection law, is about to expire. It's going to expire in a couple of weeks. So we're not going to take the extra step of stopping it, of halting it, or of striking it down right now. We're going to basically toss the ball back into Congress's court with the very firm warning that if Congress does not take care of this, like I said, either let it expire or seriously modify it, then it's going to wind up back in our court, and we're not going to be so nice to it next time around.
Interesting way to put it. Well, Mark Joseph Stern writes for Slate.com, and you can follow him on Twitter at MJS_DC. Thanks for joining us today, Mark.
Thanks a lot for having me on.
All right. Let us know what you think about this issue by sending email to tnt@twit.tv. Do you support the court's ruling? Do you think Snowden is a hero or a traitor? Just whatever's on your mind, let us know.